Welcome, everybody. Thank you for coming out today to our renter control workshop. We are representing New Direction Realty. My name is Jennifer Ramos. I'm doing this as an outreach to the community to help as much people as I can in helping them understand rent control, have a better relationship with their landlord, and understand their rights. But before we start our rent control workshop, I actually have Madeline Osorio, and she's going to talk about a little bit about, is it Medicare?
Healthcare insurance.
Healthcare insurance, I'm sorry. Healthcare insurance. We are doing this together because we're trying to get as much help to our community on the health side and also in the real estate side. So Madeline, make your way over here, present yourself, let us know what you're doing in general. Thank you.
Thank you, Jennifer.
You're welcome.
Thank you all. Good morning. So my name is Madeline Osorio. I've been in the healthcare industry for over 20 years. I'm currently working with the community here in the Newark Public Libraries to educate individuals about healthcare benefits. As you know, this coming period is the open enrollment period from October 15th to December 7th. So this is the only time that you have the opportunity to make a change to your healthcare insurance. So if you're not happy with your insurance plan, or maybe your prescriptions are not being covered under that plan, or your doctors are not being covered, then I'm definitely the person that you can talk to in reference to that. Aside from that, I also assist individuals with state programs applications such as the NJ-PAD, which is the Prescription Assistant program for the aged and disabled. And what PAD does is that it lowers your healthcare, your copayment costs for medications, depending on the qualifications for each household. There's different income guidelines for individuals and married couples. 2023 has one income guideline. 2024, as they're approaching, has a new income guideline where most people in our communities do qualify. That is a state program. There are no charges for my consultation fees, for my assistance. I only get paid by the insurance company upon enrollment. So it's very important that you know that no one should be charging you to enroll into a plan. Additionally, at this time, you may get a lot of phone calls. You'll have individuals calling you, talking to you about healthcare plans. Please be mindful that you may not know who you're speaking to on the other line, and you should not be giving them your personal information. This is a big time where there's a lot of scam that happens and a lot of hackers. So please do not share all your social security or that information over the phone. I am going to be upstairs, tabling upstairs. So if any of you have any questions, I would like to take them privately, as everyone's situation and scenarios are completely different. Again, thank you so much for having me here this morning, and thank you, Jennifer, for having me. And I look forward to hearing what you have to offer as well.
Thank you.
Thank you.
So like I said, thank you for being here again. Again, my name is Jennifer Ramos, and we're representing New Direction Realty. We're here actually in Newark. So the reason for me making this rent control workshop is because not only have I been approached about helping general people get an apartment. Right now, it's become difficult because of the prices. If you're self-employed or you have a family, and you know the rents could be higher than your income, especially here in Newark, then we have a harder time trying to find our clients an apartment. So because Newark has put enacted on June 7, 2023, a new ordinance, I wanted to be able to get it out to as many people as possible, right? So I am going to read from here, and I'm going to explain. Now, Newark, you guys can ask me for the information, I'll give it to you. So we have the Department of Economic and Housing Development Office and Boards and Commissions. So if there's any type of complaint, you guys, and we'll have this here in the show notes when we put this on YouTube. It says the Division of Rent Control Board is in the 920 Broad Street, room 111 in Newark, New Jersey. The number is 973-733-3675. I found this online because they do have the hearings of any of the complaints about tenants with their landlords. So this information is great. The next one they're going to have is on October 10th at 6 o'clock. Why do I say this? Because you have the right to be heard. More and more residents of Newark are going to complain about their landlords. Now, I'm not doing this so that we can go ahead and get the landlords out of the, as property owners, no. I'm here so that you can have a better relationship with your landlord. That's what it is. So we're also going to talk a little bit about tenants' rights. So we have protection for renters. The ordinance aims to protect the poorest residents and those who are not under rent control nor live in public housing. So if we're talking about protecting the renters, it's not a landlord or an owner that lives in the property. We're talking about an absentee owner. So they're renting out a house, 1 to 4 families. So they don't live in the dwelling, okay? These are the people who are protected for the rent control. If the landlord lives in the property, whether it's a 1 family, 1 to 4 family, then they have the right to raise the rent, okay? And we have that here, so it's not something that I'm making up. It's part of the ordinance that we have. All this information is public information and it is online, okay? So we have affordable housing efforts. This ordinance is part of a broader effort to maintain affordability in Newark, where the rapid increased property values and the conversion of owner-occupied homes into high-priced rentals by LLCs and corporate entities have been eroding the supply of affordable housing. So as we can see, more and more investors are coming into these big cities, Jersey City, Trenton, Newark, and they're buying out properties and renting them. And they make a profit out of this. However, the majority of the residents can't keep up with those rents, okay? So we made this so that housing can be affordable for the residents of Newark. Now we have a supplementary ordinance. What does this mean? Bianca, so if they're increasing the rents and these landlords are not registered with the town of Newark, okay, we can say, here it says, ordinance supplement another ordinance, the Newark Rental Registration Ordinance, which was passed in April. The ordinance requires landlords to register all rental units with the city's Department of Economic and Housing Development, aiding in the enforcement of the unconscionable rent increase ordinance. So if these landlords are not registered with Newark, however, if they increase your rent, they're also under violation, okay? They have to be registered. Now we have, what's the impact on newly developed apartments? As we have seen, there's more apartments going up, right? Besides the 4 mentioned ordinance, a related regulation limits rent increases, if this is new built, 5% are yearly in newly developed apartments buildings that were previously exempt from rent control. The violators facing fines up to $1,200. Okay, so if the landlord raises the rent, and I've had people sit here before that their rent was raised $400, $500, $600 overnight. Okay, because a new owner came in, and actually someone, I'm not gonna say names, who works at the library told me that their rent went up too. The new ordinance and related regulations reflect the constant effort of the city of Newark to address the affordability crisis, protect vulnerable renters, and ensure a balanced and fair rental market, okay? I also brought with me, and I'm gonna put this down for a moment, the Renters' Rights and the City of Newark. There's actually one online that you can get that has all the information. We just brought these, we're gonna leave them at the library, they're more digestible. They're going to be in English and in Spanish. Okay, so as I continue here, so we have the rent increase limitations. A specific ordinance limits rent increases to 5% per year for newly constructed buildings that have previously been exempt from rent control by state law. So even though they have been exempt, they only have an increase also of 5%, okay? The rent may not be increased by more than 5% for the dwellings of 49 units or less, or 4% for dwellings of 50 units or more. So the general rule would be that it's no more than 5 to 4% for these rents. Now, rent control definition, what is this definition of rent control? In Newark, the term rent controlled encompasses any building that is not owner occupied, okay? These are absentee owners. So what is happening across the United States, huge companies are buying single family and multifamilies. They don't live in the state, but they know that these rents, because we're closer to bigger cities, these rentals can go up because the housing has gone up. However, once we've had this ordinance for a long time with rent control, but it was not being respected. Now the city has enacted where they're going to increase the taxes, okay? They already done the assessment, they're gonna increase the taxes, and now the landlords are gonna have to pay the difference of what the tenants can pay, okay? Newark is a big city. It's about 250, around there, residents, and we have the elderly. A good portion of the city is children from before the age of 18. So not everybody can sustain these rents, okay? We have had an example where I had in my last tenants' rights workshop, this lady told me that she was living in the boiler room of an apartment building, and she was the super, and she was paying $800. Imagine someone much older, doesn't have any money saved, has to live in something like that, okay? So now we have COVID-19 moratorium. All rent increases of rent control units was declared due to the COVID-19 pandemic, effective retroactively from April 1st, 2020, and remaining in effect throughout the state of emergency declaration in Newark. The moratorium continued for a period of 2 months following the end of the state of emergency declaration, okay? Now, what are the exceptions? Rent cannot be raised if the apartment is not currently registered with the Office of Rent Control, right? Rent control regulations in Newark do not apply to owner-occupied, and I mentioned this before, 1, 2, 3, and 4 unit family dwellings. So if the owner lives in the property, they can raise the rent as they like. New and add-on ordinance. On June 7, 2023, Newark, New Jersey enacted a new rent control ordinance aimed at curbing unconscionable rent increases in buildings not under rent control. So that's a good sign for a lot of the residents in Newark that their building was not registered, or the dwelling is not registered with the town, with the city, so that they also can be protected from high rentals. and rents going up, rent increases. It builds upon a state anti-eviction law, which makes it illegal for a landlord to impose such a large rent increase. Okay? So like I said before, I had here people who reached out to me saying that they were $400, $600, even $1,000 that they went up in rent. And sometimes you have single mothers who have children, who have to work. They don't have an extra income. There's a lot of residents here who don't have an extra income. Now, what are these penalties? Landlords who violate this ordinance are subject to fines up to $1,200 per affected apartment. Now we have rationale behind the ordinance. The law came into effect due to a growing affordability crisis in Newark, exuberated by rent rising faster than income growth. We have seen throughout the years that the income has not grown as much as the rents have. In 2022, Newark's average rent increased by 12.2%. That's a huge jump. Okay, so that's on rent control. I'm gonna go a little bit over. Does anybody have any questions? The reason that I did this because if you guys want to take a look at this, this is the whole ordinance. It's pages and pages and pages and pages. So I feel that I took out what was most important that the public should know. But since it's because it's public notice, you guys can go ahead and go to the website. So I do have here for increases, limits. These are the laws that are here for Newark. Okay, I'm not inventing anything. That's why I wanted to read this. So the rent for any housing space shall not be increased more than the percentage stated above in a consecutive 12-month period of the number of different tenants occupying the house space during the 12-month period and any change of ownership of the landlord or vacancy of the housing space. This provision does not preclude a tenant from challenging the legality of the rent being charged immediately prior to an increase authorized by the section. Okay? So, the landlord shall rebate, that means return to the tenant any amount of rents collected in excess of that permissible pursuant to the terms of this chapter by crediting the tenant with the amount of excess rent paid. So, if the landlord is in violation of the increase, he will have to give credit back to the tenant, okay, for the amount of excess rent paid over a period not exceeding 14 months. So they have a 14-month window to pay the tenant back. Or in the event that the tenant is no longer in occupancy, by refunding it within a 1-month period, the provision is not intended to preclude a tenant from seeking judicial remedies under statutory or common law. So I did want to address that the landlord cannot evict the tenant because they cannot pay the increase. Most likely they will be in violation, okay? Let me just point out here anything else that I deem important. So the law says also that the landlord's hardship, okay, they can also appeal for the increase. So now more and more, so you guys can become aware of this, more and more landlords are appealing in the court to have it increased. So it says here, to realize a just and reasonable return on the subject property, a landlord may appeal to the board for a hardship rent increase if the landlord is unable to meet its reasonable and necessary operating expenses and earn a fair rate of return on his investment by submitting a hardship increase application. The board will hold a public hearing on the application following the procedure outlined. Inspections of the dwelling must take place before a hearing. A re-inspection may take place after the hearing as detailed in this section. An application will be granted only if the dwelling meets the definition of substantial compliance and the landlord has met the registration requirements specified in the chapter. So they are able to appeal depending on their situation. And we have here how they can do that. Let me just So we have here, it says, time period of increase. No increase pursuant to this section shall be authorized with respect to a rental unit more than once in any 12-month period. Okay, so only one time can it be increased. Nor shall the board conduct a hearing with respect to an applicant for such a rent increase of rental unit more than once within a 12-month period. Okay? There's a lot of good information here, very good information. So what is the powers of the board? The powers of the board of the rent control is to grant rental increases, decreases, or surcharge under provision of the chapter, to impose a monetary penalty to exceed $500 for a violation of any of the provision of the chapter, okay? To the point two, an administrator of the rental board for a term to coincide with the administration to an annual salary fixed by ordinance to be paid as a municipal salaries are paid, okay? Let's see. Now, for the senior citizens and disabled citizens protected from eviction. So, an applicant for protected tenancy. Acceptance by administrator shall be empowered to accept applications from senior citizens. So if you know of any senior citizen that is being evicted from their home, or disabled tenants for the purpose of determining their eligibility for protected tenancy status from eviction resulting from condominium or cooperative conversions. Appointment of hearing officer, they could contact the office, okay? So that's their rights. So here, if you are planning to have a hearing with the board, here are the steps. So we have the petition. The rent control board shall consider an adjustment of rent for an individual dwelling unit upon receipt of a petition for adjustment for rent while the landlord or tenant of such a unit are aboard. So you can have petition. The notice. The rent control board shall notify the tenants and landlords of the petitions. The records. The rent control board may request either party to rental adjustments to provide it with all pertaining books, records, and papers. Now they're going to have the hearing, an open hearing, and this is what I've mentioned before. What I have for the notice. It's right here in the front. These are the hearings that are coming up, so it's public notice. You can get in. There's a link and hear them. So we have the right to assistance. All parties to the hearing may have assistance in presenting evidence and develop their position from attorneys. And they will record these hearings. So, retaliatory eviction. Okay. So I will talk a little bit more about evictions, but I just wanted to give you enough for the rent control. And let me just see if there's anything else to address. Okay, I think that's about it. Does anybody have any other questions? No? Okay, we'll continue. So that now we have the renter's rights for the residents of Newark. So this might be a little bit of a repeat, but I want to talk about a couple of extra things that will be helpful to all the residents. Suppose you're a tenant in a multi-building with 7 rental units in Newark, New Jersey, built in 1980. In this case, the rent control guidelines would typically apply to your units. If your monthly rent is $1,000, your landlord would be limited to a maximum annual rent increase of 4%, which means the maximum rent increase in a year would be $40. Not 100, not 200, not 400, not 600, or above. Your landlord can only evict you for specific reasons outlined in the just cause eviction rules, such as a non-payment of rent or lease violations. The landlord would also need to register the property with the city, and if they violate the rent control laws, they could face fines and penalties. Please note that the rent control regulations can vary from city to city, so we're only talking about Newark. It's essential to consult the latest local ordinance or seek legal advice. Do we have the legal advice so that we can give them at the end?
No, it gives them the.
It gives them here at the end? Okay. So I will announce it. Good. And then we have seek legal advice to ensure compliance with current regulations in Newark, New Jersey. Annual rent increases are now capped at 5%. Vacancy control. Some ordinance may include vacancy decontrolled, allowing landlords to reset rents to market rates when a unit becomes vacant. So we announced the rent control board. Now, so what are the responsibilities of the tenant? In New Jersey, don't vary much from other states. Generally speaking, New Jersey landlord-tenant laws require them to comply with the following guidelines. So this is important also for the tenant, because if you don't go by the guidelines, you might be evicted. So keep the property's utilities and fixtures in good condition, pay rent on time, provide a quiet environment for other tenants or neighbors, make small fixes if needed by the property. So rent payments in New Jersey. As specified by the New Jersey law, tenant law, landlords may charge any amount of rent that they consider appropriate for their property, since there isn't in any statewide on rent prices. So in the state of New Jersey, we do not have rent control per se for the whole state. Every town and city, you would have to check to see if they have rent control. So while there aren't any statewide limits on rent prices, New Jersey permits local jurisdictions to impose rent control policies in their area. As a result of this rule, approximately 100 municipalities in the state have imposed rent control policies to make sure if the local jurisdiction has some kind of rent control policy for the property, check with your housing authority. Now we're also going to talk about late fees. Additional fees are not required by the New Jersey landlord-tenant law, but they allowed as a form of motivating tenants to pay on time. Additionally, landlords may request a fee for bounced checks after 35 days of receiving the payment. This fee may not be higher than 3 times the checks. So your landlord, he wants you to pay on the first of the month, correct? But actually you still have a 5-day grace period, okay? Security deposits in New Jersey. These are the most difficult. There is really no security deposits law saying that they have to charge you a deposit. However, it's in the best interest of the landlord to charge you a deposit if there's anything wrong with the property after leaving the property that the tenant could have made to the apartment or the dwelling, right? So the tenant can ask you for a month and a half of the security deposit in New Jersey, okay? They cannot ask you for 2 months. They cannot ask you for 3 months. They can't ask you for a year's worth of a security deposit. It would be against the law. Now, New York is different. I think New York has 3 months security deposit. So every state has their way of collecting the deposit. Now, what should the landlord do to collect that deposit? They have to give you a notice of where that money is going in, what account is going in. It should be an interest-bearing account. That interest is at 1.7%. So at the end of the year, that money should yield a 1.7% of the security deposit. Does the landlord have to give you back that percentage? Yes, they do, once they return the deposit. Now, says if the landlord decides to collect security deposits, its value shouldn't be higher than 1.5 months' rent. This deposit clause doesn't apply to owner-occupied rentals that have less than 2 units. So how does the landlord return the security deposit? Every tenant in New Jersey has a right to get their security deposit. So the landlord should itemize what needs to be fixed in the property. They cannot hold ransom your security deposit. That means they cannot say, well, I'm not gonna give you the security deposit because things have to get fixed. They have to give you back the security deposit itemized with the things that need to be done in the property. They cannot have unreasonable reasons to keep the security deposit. Let's say we're missing smoke detectors, or they're faulty, or something happened to the smoke detectors. As an example, I cannot say to my tenant, I'm keeping $3,000 of the security deposit because the smoke detectors are missing, okay? So it has to be reasonable.
Or every time, like almost landlord, they don't
Want to give the security deposit.
they find so many stuff.
They find so many stuff.
Small stuff.
But there is something what we call the wear and tear. If you have been living in the property for more than 5 years, there's things that need to be redone in the property. Paint.
Oh.
Sometimes they even redo the kitchens,
Oh, really?
the bathrooms.
Okay.
The landlord as capital investment. However, they cannot keep your money, and you can challenge them in court. I feel like there's not enough tenants out there that feel confident, because in New Jersey favors tenants more over landlords. But when they get to the courts, what happens is the tenant is not represented while the landlord is. Right? 90% of the time, the landlord is represented, but the tenant is not represented. So they might lose the case. You understand? But it's their money. Now, because rents are higher, we're not talking about $1,000. We're talking about more money, because you have to come up with the realty fee if you're doing it with a brokerage. Then it's on the tenant. Then you have to pay first month's rent, and then you also have to pay 1.5 months rent as security deposit. So as a landlord, you cannot keep ransom the security deposit. Now, it says here, this is the kicker. In these cases, the security deposit must be returned within 30 days, okay, of the tenant. The landlord had to give you a receipt. There's a paper that they download, they sign, and they tell you where the money is and how much money you gave them, okay? And it says here, if the tenant, they have 30 days until leaving the unit. If the tenant was displaced from the rental unit due to fires, floods, or excavations, they might get the security deposit within 5 days, okay? If the tenant was a domestic violence victim, the landlord must provide the security deposit in 15 days. However, the tenant must provide the proof of domestic violence in their rental unit to get the deposit in time. So what does that mean? What happens if the landlord doesn't give you the security deposit in 30 days? Does anybody know? No? They have to pay double.
Oh, really?
Yes, they have to pay double. So if you gave them $2,000, now they have to give you $4,000 back, okay? As the same way that we motivate the tenants to keep the property in good standing with the security deposit and late fees, the courts motivate the landlord to give those security deposits back because it's owed to the tenant. And so after 30 days, it's doubled. And you can challenge that in the courts. Of course, I'm not an attorney. I just wanted to say that. I should have said that in the beginning. I'm not an attorney. This is public notice information. You can find it online. Okay. So we have, again, withholding the deposit. According to New Jersey landlord-tenants laws, the landlord may withhold the security deposit in the following cases: unpaid rent or utility bills, breaches in the lease, and damages that exceed regular wear and tear. But of course, if you need an attorney, it's better that you get an attorney to be able to challenge this with your landlord. In these cases, landlords must provide the tenant with a list of deductions from the security deposit in 30 days following the tenant's departure from the rental. Okay? Lease termination clauses in New Jersey. So how can we terminate a lease? What is a lease in first place? A lease it's a document, it's an agreement that you have with the landlord, that you're gonna live in the premises, you're going to pay the monthly rent, you're gonna keep up the property. Now, when you're sitting down with the landlord, you're gonna have somehow of a deduction. Maybe it's the first $100 or $200 or $50, right? However, anything major is on the landlord. So if you break a light bulb and you have to change it, you don't have to call the landlord. Or something minor, you can do it yourself if you agree that with the landlord, okay? So now it says here, tenants in New Jersey can terminate the lease if they desire. However, what happens with that? You might still be liable to pay the months that you are not occupying the property. They must send you a particular amount of notice depending on the type of lease. Here's an overview of the minimum amount of notice needed for the landlord. So it's a weekly lease, 7 days of a notice that you're leaving. A monthly lease, 30-day notice that you're leaving. However, if it's a yearly lease, we're not gonna wait a year to let the landlord know. So the state of New Jersey says we have 90 days that we can inform the landlord that we're leaving, okay? So tenants can break a lease before it ends for any of the following reasons. If the landlord is harassing you, okay? Or domestic violence, or asking you to do something for them so that you don't have to pay the rent. Maybe it could be a sexual assault. You can terminate that lease. Health issues with the property. Early termination clauses that are stated in the lease. Active military duty and unacceptable living conditions. Okay? So let's say that for some reason now you don't have heat, water, okay, and the house or the dwelling is inhabitable. There are people that live under these conditions, believe it or not. Okay, so what happens is if there's no heat or water, you can't live in the premises. It's uninhabitable. So what can you do? So there's something that you can evict yourself from the property. It's called constructive eviction.
Question on eviction. Let's say you have a tenant. The tenant turns the apartment into
Sir, can you
house of
present
horrors.
yourself?
No.
Can you just move
No,
up because I don't know if
Let's
I
say
can
the
hear
tenant
you.
turns the apartment into a house of horrors, doesn't maintain the property. Your landlord can legally get you out.
Well, you still have to do actual eviction
Mhm.
to get them out. Even if that's one reason to bring it to the court that you do the eviction, because they have destroyed the premises.
Mhm.
So if they destroy the premises, you can't evict them, but you still have to you have to notify them and you have to go through the eviction process. If the tenant stops paying the rent,
Mhm.
right? You don't have, in New Jersey, you don't have to send them a notice, and you can get them through the eviction process. Okay? However, this is the kicker. A lot of people don't understand this. Well, my tenant owes me 6 months worth of rent, right? So I want to get paid for that rent before they leave, before I evict them. As soon as you take even 1 penny, you have settled for those 6 months. Okay? So you have to be very mindful. If you don't want the tenant to be in the property as a landlord, you have to go through eviction process and then additionally sue them for those 6 months. That is not the same thing. The eviction and getting the money judgment are two separate things. People think that, okay, because I evict them, I'm going to get my money back, right? And that's wrongly because you have to do it separate. Or if I go ahead, well, you owe me 6 months, pay me, and then I'm going to evict you. It doesn't happen that way, okay? So I was talking about constructive eviction. So the constructive eviction is where there's no water, there's no heat, and now you can't even live in the dwelling. Okay, I had one client prospect tell me that there was water coming inside their apartment. So what should they do? So I said, well, you have to go to the town or the city of Newark and say, listen, I can't live in this dwelling. You just can't say, okay, I'm leaving and I'm not gonna let the landlord know, but now he's gonna have to pay for me to be out of the apartment. No, you have to register, you have to let them know, you have to do a constructive notice saying that the house is inhabitable, they'll do an inspection, and then the landlord can pay for you to stay somewhere where you have to pay until they fix it, and he has or she has to pay for that. Okay? So, and disorderly conduct, criminal activity, and non-payment of rent, breaches in contract terms is something that you can be evicted for. If the tenants were involved in illegal activities, landlords must send a 3-day notice to quit the rental premises. So disorderly conduct, destroying of the property, 3 days notice. Okay? Is it permitted to evict a tenant in retaliation in New Jersey? So now the tenant took you to court, or the tenant did something that made the landlord angry. Now he wants to retaliate, right? It says here, no, it's prohibited of New Jersey, the landlord-tenant laws, to evict tenants in retaliation or discriminatory actions. Okay? So now, what happens if the landlord wants to re-enter the property, right? Because once you do that lease with them, they have possession of the property and quiet enjoyment. As a landlord, you have the right to come once a year, and you have to give notice to the tenant. You cannot knock on their door and what are they doing, or enter the apartment without the tenant knowing, because they have that right through the lease as possession of the apartment. Okay? If you're coming and it's an emergency, let the tenant know. Okay? But you cannot show up whenever you want, trying to look at the property or make the tenant uncomfortable. So listen to this. It says a tenant also has enough rights to refuse the entry. I had, because I do teach real estate, I had a student tell me that she owned several apartments in Jersey City, and every time her tenant paid on time, first day of the month. However, she wouldn't even let the health inspector inside her apartment. So that's the thing. They can deny you entry. All right? So only in cases where the landlord's an emergency, the landlord doesn't have to send any kind of notice before entering. Of course, an emergency, but usually it's better to call and talk to the tenant. Now, we are going to talk a little bit about discrimination, and I have a couple of other things that are useful for this workshop. So, the New Jersey Attorney General's Division of Civil Rights and Fair Housing Act offer information regarding discrimination protection rights for tenants. According to these laws, the landlord cannot discriminate against their tenants because of their race, color, national origin, sex, gender identity, or familial status. So what does that mean? Families with children. And we can go into even more on that, but I'm just gonna keep this basic. If you do want more information, you can contact me. My information, I will give it at the end. So one of the things that a landlord has to do that a lot of the times they don't do is give disclosures. What is a disclosure? It's in their best benefit to have a disclosure. Why? It says, New Jersey landlord-tenant laws offer information on some essential clauses that should always be included in the rent contract. So that means in the lease. Read below for more information on these disclosures. So one of the things that the landlord has to give a tenant that is coming into an apartment or a home, they have to give them a lead-based paint disclosure. That means if the house was built before 1978, there might be lead in the house. So children are very susceptible to eating the paint chips. Children are susceptible to being in contact with lead. So you're supposed to give them, as a landlord, an EPA pamphlet, knowing them about lead. And if they want to do an inspection of the property before they move in as a tenant, because we always think this as a buyer. But as a tenant, you have the right to do a lead-based paint inspection and have a remediation of any lead-based paint in the house, okay? You go to the landlord, they can take care of it. Now, crime insurance, that's another one that should have, insurance, the tenant should have this for themselves. When you're renting, it says landlords have to present information regarding the federal crime insurance program of Housing and Urban Development Act of 1970. Now, the landlord also has to tell you if the house is on a flood zone map. I don't know if you guys remember what happened in some of the areas that got flooded. We had a huge storm in New Jersey. I'm not sure, it was 2 years ago, Jose? 3 years ago?
2 years.
2 years ago, and there's some people that died in the basements because they got flooded. So the landlord must inform the tenant in New Jersey if the apartment is a potential flood zone. Now, the next one says certificate of registration. The landlord-tenant laws require landlords in New Jersey to give the tenant a registration certificate up to 30 days after signing the contract. Okay. Conclusion, at first glance, it may seem like the landlord-tenants laws in New Jersey are overwhelming. However, if you follow each guidelines carefully, you're going to ensure a great landlord-tenant relationship. And this is why we are doing this from our office, from our company, to inform as much as we can. This is very basic, like I mentioned before, for the community, but if you have more questions that you would like to ask us or find out, we're happy to help out the community. Does anybody have any questions before we conclude? Carl?
I have a question. Yeah, I was trying to figure this out with my neighbors. I live in a 70-unit building, pre-1987, so it falls under rent control guidelines.
87 or 78?
What was the one?
It's 78.
Oh, 78, okay. It's an old building though, and when somebody moves out, right, and the unit becomes vacant, we notice when it goes back on the market, they will skyrocket the price. Sometimes like double what I'm paying, like the new person who moves in next door will pay. Are they allowed to just raise the vacant unit to like whatever amount, or is there like a limit, or is there a way to find out like what it could potentially
Possibly
be?
be. So the first question that I would ask is, in what town do you live?
I live here in Newark.
Okay, so you live in Newark. So when I was reading here, in this document right here, for the 49, is it 49 and plus units?
Yes.
Okay. So I'll read it again. So it says rent increase limitations. A specific ordinance limits rent increases to 5% for newly constructed. So it's not a newly constructed building. It's a building that has been there. So this is the second one. The rents may not be increased by more than 5% for dwellings of 49 units or less, or 4% for dwellings of 50 units or more. So your landlord or the LLC or the people who are in charge are in violation.
Even if it becomes vacant, they can't, it still has to be 4%?
Yes, because they have 49 units or more.
Okay.
So you can go ahead and call the rent control board and say, well, I feel like some of the tenants are not complaining, they're just taking it as is, but the rents are just skyrocketing. Is this building registered? I work with the public library, whatever it is. So that's a really good question, really good question. Because I feel like there's so much general information, but then what do you do? But like I said, I'm not an attorney. We were having an attorney come with us here today, but actually they had something else that they ended up having to do. I will do more of these because I feel like the information still has to be challenged and given out. Probably I'll have another attorney here. But yes, you need to look for legal services. Catholic charities have legal services. And in downtown Newark, did you have that information?
I'll include it on the YouTube channel.
You'll include it in the YouTube channel?
Now, I've got a question for you.
Sure.
On lead. A couple of months ago, I was here at the library and somebody approached me and she asked me if I knew anything about lead laws. I asked her why. She says she was being evicted by her landlord because the property was subject to inspection and they found lead-based paint. And he had to make remediation. I'm saying, how can he evict you? Is there any way that this landlord had to actually put her in another place while he got the property remediated for lead, or no?
So the first thing, well, there's a lot of information that even the landlords are not aware. But he should have given her, as part of what I just said, the lead-based paint inspection before she even moved into the.
Yeah, she
The
had moved in,
unit.
she moved in the apartment, 3 months into living in the apartment, he had it inspected, lo and behold, they found lead. They told him he had to have it remediated. Well, what does she do? I mean, he basically gave her a letter telling her, you gotta go.
Exactly.
I mean, there's gotta be some type of legal protection for this tenant.
For legal repercussion. So the thing is that there's a difference when you work with a realtor because we give those disclosures at the beginning for the renter. However, she would have had to go down to consumer affairs, not even rent control. This is just a whole different unit. Consumer affairs, talk to consumer affairs and let them know, look, I'm being evicted because they found lead in the property. What should I do? Because then that would be something that consumer affairs can help them with. Maybe send a notice to the landlord. I would say, I couldn't say to do constructive notice because I don't know right now the degree of lead in the property. So they would just have to talk to consumer affairs. Okay. Anybody else has a question? Madeline?
So,
Go ahead, Manish.
As example, I'm living in an apartment from say like 6-7 years. So my rent is like example $1,800, and now there are like 2 or 3 apartments are vacant. So the landlord can give that apartment on whatever the market price is now going on.
Let me ask you a question that I asked Carl. What city or town do you live in?
Woodbridge.
Woodbridge. So we would have to find out Woodbridge rent control increases. One. Now, does the owner occupy the house? So it might be, I don't have Woodbridge information here, but
No,
it might
it's a
be.
general just.
Yeah, general, it might be if the owner occupies the unit and then rents the other ones out. From what I know from Newark, they can raise their rent as they like. Yeah. Now, I had another person here on one of my tenants' rights workshop where their daughter lived in Livingston. And they went from 1,800 to like almost 3,000 for the rent increase. So if we go to specific towns, like let's say Livingston, a judge would say, well, it's a reasonable increase. Why? Because those homes are expensive and we don't have rental income. So, I'm saying rental increase. So now there's about 100 municipalities in the state of New Jersey that have recently enacted within these 2 years rent control. So you have to go online and find your town if it does have rent control. Okay. Does that answer it for you?
Yeah.
Okay.
And one more question. Is
Sure.
it the same law apply into Airbnb?
The same law applies to Airbnb. Well, now with Airbnb, there has been a lot of law changes.
Yeah, because it's a short term, like
Yes.
2 days, 3 days, or 5 days or a week. That's
Yeah,
it.
so you're not staying. See, this is the thing with Airbnbs right now. Like New York. New York has said that
Yeah.
Airbnbs cannot rent for more than 30 days out of the year.
Yeah, and then now there is a new law in the New York that now they have to register as a Airbnb property, and now city is asking for the tax on that.
Yes, so they're asking for the taxes. So what happened was that these owners of Airbnbs didn't have to pay taxes, right? So now they do. And because there's legislation around it, you're not staying there long enough to say, okay, this is an increase. The owner can put what they want for the rent. Now, everybody's getting hit, all the states are getting hit with Airbnb. So I've had a lot of complaints. So let's leave Airbnb for another workshop. Go
Hang on,
ahead.
one more
Thank you,
question.
Manish, I appreciate it.
If your landlord's being foreclosed on,
Oh, yes,
Okay.
foreclosures, yes, that was something that I was going to talk about, thank you for reminding me.
should you keep on paying your rent or say, hey, I'm living for free?
So this is what happens to a lot of tenants who think that, okay, my landlord's losing his house, why do I gotta pay rent, right? You have to pay the rent. So if you do not pay the rent, the landlord can evict you or force you to pay the rent, or you have to go, okay? Why? Because what happens is that this owner landlord is struggling to make the payments to keep the house. If the tenant is not doing their share of paying for the rent, they're not helping the landlord keep his home. So by law, they have to make sure they pay the rent. Now, what happens if the landlord didn't say anything to the tenant? And then finally they are foreclosed and the landlord has to leave, the owner has to leave the premises. The tenant, if they keep paying the rent, they will have a grace period from the bank to find another apartment, but they have to pay for the time they've been there before and after in the apartment or dwelling.
Okay, one more question.
Okay.
Okay, let's say I'm a tenant, I lived in this building for 10 years, lo and behold, and I have a lease. My lease runs out at the end of the year. My landlord goes out and sells the apartment in May. Does the new owner have to honor my lease till it closes, or can he buy my lease out?
Can he buy your lease or increase your rent?
No, can he buy my lease out, or does he have to honor my lease till it expires?
Okay, so what you're trying to say, and I'm gonna say it again, you were renting there for 10 years.
Mhm.
The lease is up. How many more months is the lease up?
It's at the end, it's, let's say December, but it's May, my landlord just sold the building.
Okay. So they have to honor it.
Mhm.
They have to honor it. They can't buy it out. There's no such thing as buying out the lease. Now, let's say I am there 10 years. My lease is up in December and I want to leave the premises. Now the landlord can say to me, well, these months are due. So what are you gonna do? There's actually a clause in the lease that says that the landlord can look if you leave the premises and you might still have to pay the landlord for the months, but they have the right to find someone else as you leave, vacate the property. And that also happens with Airbnbs and those kind of rentals. If for some reason you don't honor the rental for an Airbnb and then you want your money back, the owner doesn't have to give you your money back because there was no notice and they can rent it to somebody else.
No.
Okay, but they still have to honor the lease. Yes, go ahead.
2 questions. First one, for homes that have been built before 1978, upon putting them in the market, is the seller responsible for doing lead testing or the buyer?
Okay, so if you are an owner, I'm gonna say back your question so that whoever's watching us, they can understand. And you're now putting your house on the market, right? You are allowed to do that. Now your house was built before, it was built in 1920, so it was built before 1978. So what happens is you have to give a disclosure. There's 2 disclosures. There's a property disclosure and there's a lead-based disclosure, lead-based paint disclosure, which means that as a good faith act, you're letting the public know, any buyer that's coming to the property, that there might be lead in the house. But you are going to put it in writing saying that this is what you know about the house, right? The property disclosure will say everything about the house that you know. The roof is 15 years old, the HVAC is 10 years old, you know, all that information. And then in the lead-based paint disclosure, you just have to let them know if you have seen lead. Now, if you say, okay, I have not seen lead, but I cannot testify for that, there needs to be an inspection. Regardless, you have to give that to your buyer and they have 10 days that they can do an inspection for that. Now, it's upon the negotiations who takes care of the lead problem. So with the attorneys.
Now, on the other side, if the resident has been living there for a long period of time and the apartment have not been tested, can they go ahead and proceed with doing their own testing?
So if the tenant's been there for a long time and then the landlord says, hey, I think we should get the apartment tested because I didn't know that before and now I wanna do it, if it's something like that?
Or no, the landlord doesn't want to do it, but the person suspects that there may be something wrong.
Okay, Home Depot, you could buy these little sticks
Mhm.
and break them in half and go where you think there's lead and you rub it. If it's a red reaction, you have lead.
Okay.
Way back when I moved, that was one of the first things I did, and it was lead.
Oh,
I bought it to the owner and filter from lead. What do you want me to do about it? I stayed there for about 2 months and then I'm out.
Yeah, for that, those are scenarios, so you definitely need an attorney to see what can be done, because you're already in the property.
Mhm.
We're kind of talking more about what we try to prevent before, right? But, yeah, lead is, especially if there's, small children in the property, they might have to look for another place to go. Thank you, Madeline, for all the questions. Any more questions? No?
Does it
No
apply
questions?
to lead in the tap water too? Because over the years in Newark, we've had a lot of issues with lead being in tap water lines in especially single family homes.
So that wouldn't really be the owner's responsibility, that would be the town's
That's the town's.
responsibility. And so I know that here in Newark, they were giving out water because of the lead base, that was coming in through the water. Especially in a city that this big, there's issues with the water. So they recommend that the residents buy bottled water, or if they can't buy the bottled water, then the town provides it for them. However, in the past, I believe 3 to 4 years, they've been excavating and taking out all the lead-based pipes on the ground so that we can have better drinking water. But of course, there is a report that they sent out to all the residents every year, letting you know how we're doing with our water.
And I got one more.
Sure.
Okay, let's say you're living in an apartment, let's say you need a window replaced. And you're talking to your landlord, oh, I'll get it replaced. It's like 5 years, you still need the window replaced. Can a tenant hire an outside contractor, come in, replace the window and deduct it from the rent legally?
So if there needs to be, because that falls into a major repair.
Mhm.
A window is not something that a tenant can easily do, right? So that you might have to hire a contractor. You can hire a contractor, or let's say something that needs a major repair and you had someone else repair it,
Mhm.
you can deduct it from the rent.
Okay.
So I had someone that was a client of mine, lived in an apartment, the water heater went out, the landlord took forever, had it repaired, billed the landlord, and he deducted it from the rent,
Okay,
okay?
I'm done.
You're done? Okay. Anybody else? All right, so can I just have that for my information? So I do have information here for you guys in case you wanna take it. Here's my information. This is the company that we're in. If there's any other questions, I'm not here to make you buy or sell. I'm just here to give you information so that you can take my information with you. If you need help with other people that you know, pass the information around. That is helpful to the community. But thank you, everybody, for coming. I appreciate it. Thank you so much.
Thank you.
Thank you.